Good afternoon. May it please the court. My name is George Norton of the McNairy County Bar, and I represent the appellate, Kurt Miles. I would like to reserve 3 minutes for rebuttal.
All right, sir. You may proceed.
Thank you. The appellate asked this honorable court to reverse the trial court's order entered on October 27 of 2021 because the trial court reached an illogical decision by not properly weighing the best interest factors as outlined in TCA 366106, and the decision is not in the child's best interest. This case concerns a custody dispute between mother and father regarding a now 16-year-old daughter. The child at issue has had numerous mental health and behavioral issues over the years, and the record indicates that she is in need of long-term residential treatment and a change in her environment. The mother has refused, according to the record, to comply with the request of numerous mental health providers and is easily manipulated by the child. Testimony from Veldon Reedy, a licensed clinical social worker at trial, warned the trial court during his testimony that the child was capable of manipulating the trial court, his parents, and her parents and people of authority. He also concurred with the medical providers that the child needed long-term residential treatment to address her issues.
Are we talking about custody or visitation here?
Custody and decision-making, Your Honor.
Okay.
Particularly the decision of father to be able to make medical decisions.
Do you have a final judgment here?
I believe so, Your Honor.
What's the visitation currently?
To father every other weekend.
Is that something that's actually being done, or is that something that just the order provides?
It's just something that the order provides.
Okay, so you have a complete order. It's just, so how is that, well, how was that left with the trial court?
From the order October 27th of 2021, it just provided that father should resume family counseling with the child, with Veldon Reedy, and his visitation was left in place. Of course, that's not being complied with.
Well, and I'm not articulating this very well at all. Are there certain markers that need to be met before visitation resumes, or how does this?
The court did not put those markers down, Your Honor. They're not in the record of any sort. And in fact, the father was left with that order and had not been able to exercise visitation for about 3 years, other than outside the setting of Dr. or Veldon Reedy, the licensed clinical social worker. And at some point, those visits were recommended to be stopped by Veldon Reedy because of the child's manipulation and the relationship and her issues that were going on.
So let me make sure I understand this correctly. So this is about custody, but there is no visitation, although visitation is being ordered.
Yes, Your Honor.
And it's my understanding that essentially the expert who testified before the trial court said there shouldn't be any visitation at this point in time.
He said there should not be visitation years ago. I don't think that he specifically said that now. His recommendation was that the child go to a long-term treatment facility to address her emotional and mental health issues.
Well, that's what I'm trying to get at, and I'm apparently trying to get at an issue that's not an issue, but there is no visitation. There is no marker that you've got to reach where visitation will be considered, but this is about custody rather than visitation. Is that right?
That's correct, Your Honor.
Okay. Go right ahead.
And, Your Honor, the mother refused to allow the child to get this residential treatment that was recommended, and at least on one occasion went against medical advice and withdrew the child from perimeter health care facility after a suicide attempt. The child is highly emotional with a record of suicidal ideation, suicidal attempts, overdoses, trouble in school, depression, anxiety, bedwetting, pseudo-seizures, at least 10 different mental health diagnoses from many different mental health providers. And she has the ability, according to the record, to use her emotions to manipulate authority figures to get what she wants, which oftentimes is not in her best interest. In this case, the trial court disregarded significant factors in determining what parenting arrangement was in the child's best interest. The record is void of a proper finding of fact and balancing of the factors provided in TCA 36-6-106. For instance, the court failed to properly consider the strength, nature, and stability of the child's relationship with mother. Here, the court failed to recognize that mother had a tenuous relationship with the child and had allowed numerous behavioral issues to develop without proper treatment. Even after being advised to keep medication and sharp objects away from the child, the mother did not, and suicide attempts continued while in her care. She allowed the relationship to be manipulated by the child. Secondly, the court failed to properly weigh the parties' past and potential future performance of parenting responsibilities, and the mother's history of denying parenting time to the father and violating orders of the trial court. In its order, the trial court stated that the father had been less compliant with court orders than the mother, but the record indicates otherwise. The father never intentionally disobeyed any order of the court. The mother, on the other hand, had refused father parenting time on numerous occasions, allowed the stepfather to be around the child in direct violation of the trial court's order, even though he was using drugs as recently as 2 months prior to the trial date. And she repeatedly refused to follow the medical advice for the child to remain in care and to enter into a long-term facility for treatment. The father had always followed court orders, never went against medical advice, and indicated at trial that had he had medical decision-making authority, he would comply with what the mental health professionals recommended. The trial court failed to consider that the father has a better disposition to provide for the child's medical and other necessary care and is not easily manipulated by the child. The court also failed to properly consider the emotional needs of the child and the developmental level of the child. Here, Zoe, the child, is highly emotional. She's a child of a record with delinquent offenses such as theft, overdosing, trouble in school, and the other issues that I've mentioned. She's easily manipulative of authority figures and even the court. The court order found that Zoe should not be left alone for extended periods of time, should continue individual and family counseling. However, this did not go far enough. The record is clear, including the testimony of Eldon Reedy, that the child needed long-term inpatient care so that she could receive proper medical attention and would not be able to manipulate the providers. In mother's care, the child has engaged in risky behavior, alcohol and drug use, and sexual activity. It is clear on the face of the record that the mother has failed to adequately supervise the child and to attend to her emotional and behavioral issues which warrant long-term care. The court failed to properly weigh the moral, physical, mental, and emotional fitness of each parent as it relates to their ability to parent. Mother expressed an unwillingness to participate in counseling sessions with Eldon Reedy and to comply with medical advice. The record indicates she does not properly supervise or reprimand Zoe for her bad behavior. The child had been in 3 different schools in mother's care. The child is now, at the time of trial, was homebound. The child was left at home for extended periods of time, unsupervised during the day when she was supposed to be attending to her school needs. The child attended no extracurricular activities, had a minimal interaction with other children or other than her sisters. This was not the case when the child was in the care of the father. The court failed to consider the child's involvement with physical surroundings, school, and other significant activities. While in the father's care, the child went water skiing, went on a mission trip, and her medical needs were met. The trial court failed to recognize and make a proper finding of fact that the child is not in a satisfactory environment with the mother for various reasons. The child was sneaking out of the home, using alcohol, using drugs, having sex, sending nude photos, stole a credit card from a family friend, overdosed, and was around their stepfather, who was admittedly a drug user, at least 2 months prior to trial, which is in direct violation of the trial court's order. The record indicated that there had been no credible allegations of abuse by the father and that the child was easily capable of manipulation.
The child's going to be 17 next month?
Yes, Your Honor. The court considered...
Didn't the trial court consider whether the child should be around the step-parent?
The trial court did consider that and amended that earlier order to allow the child to be around the stepfather. When the evidence preponderates against that, the stepfather indicated his alcohol problem had resurfaced and that he had used drugs at least 2 months prior to trial, and my client believes the record does not indicate that she should be around that person. The trial court did consider the preference of the child, but the appellant argues that the trial court put too much weight on that preference, given the child's history and ability to manipulate her parents, medical providers, and people of authority. The appellant believes that the best interest of this child, who is quickly reaching the age of majority, would be to allow him to make medical decisions and educational decisions, and for this child to get proper treatment and proper education and proper supervision. The current trial court order does not allow that. Thank you.
Thank you. Ms. Miles, if you come up, please. Ma'am, I need for you, when you begin your argument, just to tell us who you are, because all this is being both recorded, both by video and audio, and then you can tell us whatever you want. The lighting system on the monitor there on the podium will indicate your time. You've got 15 minutes. You can take all of it or not, whichever you prefer.
Thank you, sir. Good afternoon, Your Honors. My name is Nikki Barnett. I'm representing myself pro se. I'm the appellee in this case. Thank you for allowing me to present my arguments today.
Yes, ma'am.
I waited 5.5 years for the decision from Your Honorable Chancellor Butler. It was a decision that I'd prayed for many times. I did not agree with every decision he made, but ultimately it was a win for my daughter, and that I can live with. I originally filed my first motion in February of 2017. Me and Mr. Miles, upon our divorce, we agreed to co-parent and split the time equally, and we did that fabulously in the beginning. He paid me $400 a month child support. I had her 2 weeks of the month. He had her 2 weeks of the month, but I was the primary custodial parent. Zoe's mental health rapidly started declining in 2017. Actually, 2016. I talked with Mr. Miles multiple times. One time, him calling. He's also major depressive disorder diagnosed and has obsessive compulsive personality disorder with narcissism. I talked with him numerous times and told him that Zoe was starting to fail to thrive and that we needed to do something. I encouraged him to go to counseling. He did not do so. Repeated whippings, over punishment, punishing Zoe for soiling the bed when she was clearly scared. Those things brought me to file the original motion to get parenting plan modified to where I had her more of the time, and I wanted child support to be done differently. I've been the only parent that has all these medical professionals that Mr. Norton has talked about. I'm the parent that took her there. I'm the parent that took her to, that has called crisis. I'm the parent that called crisis. I'm the parent that has taken her to counseling every week for the past 5.5 years. I am the parent that has drove her to Nashville to be hospitalized numerous times. I did take her to Parameter at one time here in Jackson. She was violently beaten here at Parameter. I called the cops, had them to take me to Parameter, and we got my child out. At that time, I called Mr. Miles. He would not answer the phone. He has not answered a phone call from me in 5 years. I called the school that Zoe attended and talked to the principal and asked the principal, because I wanted to get Zoe into the best residential treatment at that time, which was in Wisconsin, called the Rogers Institute. Asked him to help me pay for it. I couldn't afford it by myself. He refused.
Is the child in residential treatment now?
No, my child is thriving now and is no longer in need of residential treatment. Right now, my daughter's 3 weeks from being 17 years old. She's an AB student at school. She starts dual enrollment classes in January. She has a part-time job, and she has her first car. She's happy, healthy, and thriving. Her counseling went from multiple times a week to 1 week to every 2 weeks to now we are graduated to an as-needed basis with counseling. That just started in the last few months. When a child has mental health issues, it goes up and down. And yes, there was times me and Zoe were bumping heads, because when you're trying to bump heads with a girl that's trying to take her life, then I'm not always the favorite parent, you know. So there was time that mine and her relationship was rocky, but I was not trying to be her friend. I have been the one that's been there. Mr. Miles testified in court, well, you know, since I've stepped away, the child still has had attempts. The child had attempt because the moment that Mr. Miles walked away, her mental illness did not leave. She still had post-traumatic stress disorder, major depressive disorder, all the other things that was going on. It didn't resolve just by Mr. Miles stepping away. I've never refused for Kurt Miles to come and pick up his daughter for visitation. He has not one time in the last 5 years called his daughter on the phone. He knows her cell phone number. He sent her a text message on her birthday. He sent her a card saying he donated, in 2018, saying he donated her Christmas and her birthday to St. Jude. She's never received another card. I begged him to help me pay for medical bills, because over the past 6 years, as you can imagine, the medical bills, everything is very high for a child that's had this much care. He has not paid one medical bill. He's been ruled to pay one on medical. He has not helped. He also was ruled, they changed the modification in child support, because originally he paid $400 and we shared her equal time. When the judge ruled, he did not go retroactive to when I started taking care of Zoe 365 days a year by myself in 2018. But in August, when he did rule to increase child support, he increased it to $774, and Mr. Miles still has failed to continue to increase the child support. I receive his original $400 a month is what he sends me. That's all he has sent me. I beg the court to leave Chancellor Butler's ruling in place, as he was there for 5.5 years. He heard all the evidence. In the 44-page brief that Mr. Norton submitted, he pointed out any little thing he could in a box full of papers from our trial that tried to make me look like a bad parent. Mr. Butler knows I'm not a bad parent. Every medical decision that has been needed to be had on Zoe's behalf, I have made. The ruling, he asked for them to continue counseling. Mr. Miles has not tried to see his daughter. He has not tried to go to counseling. He has, and I also wanted to note that Belden Reedy is also the one who said that he wanted her to go to residential treatment. Well, I did too. At that time, it was needed. It's not needed now. But Belden Reedy has seen Kurt on a counselor, therapist basis alone. He is not just Zoe and Kurt's counselor. So I felt like I wanted to see another counselor because I feel like Mr. Belden Reedy had a bias as to Kurt because he did actively see Kurt and talk with him on, various occasions that Zoe wasn't present. That's it. Thank you.
Thank you, ma'am. Mr. Norton, I believe you have 3 minutes.
It pleased the court. Judge Stafford, I did want to address one of your questions about whether or not the court order had left the father with any visitation. The October 27, 2021 order does not indicate a specific time for the father to visit. It simply says that the parties would continue family counseling with Belden Reedy, and father and Zoe need to try and have some semblance of a relationship. The sooner the better, but there are no specific findings for visitation of the father. And
That's not an issue, is it?
it is an issue, Judge.
Well, I mean, you didn't raise it as an issue. You raised custody, didn't you?
Well, I did raise custody, and that's an issue too, because without father having the right to make medical decisions, educational decisions, then the child will not get the proper attention that the child needs, as indicated by the record. And I know that the appellee has raised in her argument many facts that are not in the record today, but the facts before the court in the record are that the child was in need of residential treatment, and the mother did not allow that to take place.
Did the court find that?
The court did not find that, and the court failed to properly balance these best interest factors and to explain why the child was not in need of residential treatment, despite the record being that the child was in need of treatment and all of the different behavioral and emotional issues that the child was continuing to have even while the case was progressing at the trial level. And the appellant understands this child will be 17 next month, and there's not much time left. But if, based on the record, the child having the issues the child has, without he being allowed to exercise his constitutional right to parent his child and make decisions, then this child may have problems for long.
What constitutional right has been taken away from him?
Under the court's current order, there's no specific designated time for visitation or for him to make medical decisions, educational decisions, or decisions about extracurricular activities.
The court determines those issues based upon the facts and the law, correct?
That's correct, Your Honor, and the appellant believes that based on the record, the court did not properly balance the best interest factors, and the order is devoid of the proper balancing test. Thank you.
Thank you. All right, we will take a brief recess, and when we come back, Miss Angie, if you'll have the next case ready for us to go, we'll go ahead and hear that. Folks, we will get you an opinion. We're going to take the matter under advisement, and we'll get you an opinion as quickly as possible, okay?
Thank you.
Thank you.
All rise.